Welcome back, everyone, to this episode of This Dude Started Something. Today, we have a patent attorney with over 2 decades of experience and more than 700 issued U.S. patents under his belt. If there is a more efficient way to protect an idea, he's probably already got it patented.
They call him Patented Bear. Meet Austin Bonderer. How you doing, Austin?
Pretty good, guys. How are y'all?
Doing
Great.
great, man. Thanks for being here.
Yeah.
Appreciate it.
All right, so let's hop into this. For our viewers out there and also for us, tell us a little bit about patents. What is a patent?
It's just kind of basically at the end of the day, a government granted monopoly on your product. So
Dang.
basically, you can exclude everyone from making it, using it. You could sue people. You can keep
Mm,
it, from being on the market, which a lot of companies do. And there's a lot of backlash for that. You can become a patent troll, which a lot of people do. And there's a lot of backlash against that. But at the end of the day, it's your property and you
mm.
get to prevent people from using it.
Okay.
Patent troll, like, do you mean like they kind of like patent a bunch of stuff and then
Oh
like,
yeah, I mean, so when I worked at the patent office, I was an examiner for 5.5 years,
uh-huh.
and stats are stats, but the what they would always throw around is like maybe 5% of all patents are ever make it to the market,
Wow.
and that's for a
That's
lot of
nuts.
things. Like big corporations are just doing research and development, so they're patenting everything that they do because that's what it's for. And sometimes technology moves faster in the marketplace, so your patent's not really valuable until 10 years down the road. And
Mm.
then, when you have your independent inventors, when they call me, I tell them the easiest part of this process, and it's not easy, is getting the patent. The hardest part is getting your product to market.
Yeah.
Yeah.
Yeah, huh. So some like corporations have like people literally working for them and like submitting patents, like or like trying to figure out like how to get something patent. That's like such an advantage compared to like the individual, inventor probably,
Oh, yeah.
right?
Of course, it's the money. I mean, they have the
Yeah.
money means their budgets are just, I mean, one of the things is they spend all this money on research and development. They're going to use the patent process to protect that investment. And so, yeah, they
Mhm.
have
Yeah.
operating procedures in place. I mean, 3M is probably notorious that, people just get tons of patents working there, but all they get from the company is a little plaque for every time one of their patents issues or something.
So what goes into it? Like, what do you need? Say I have an invention. What do I need to do or file in order to actually get it done? Do I just need to have an idea, a prototype? Like, what do I need to have?
So you don't really have to build a prototype. I mean, so there's when people come to me, they're at all different stages. Some people are like back of the napkin, and sometimes that's
Mm,
enough. Other times they built prototypes and this kind of stuff, tested out their idea. But at the end of the day, what you really need to have is your idea or your product developed enough that one of ordinary skill in the art could make it. So I get a lot of times like clients come up and they're like, look, I don't know how to wire things, but I came up with this idea for an electronic
mm,
device. You don't have to know how to do that. You just have to explain it such that one who would know how to do that could make it.
okay.
So yeah, I mean, you just need to have the idea. And I mean, it needs to be polished enough that it's a real concept and it's there. But you don't have to have the wiring diagram or the construction or the molds made or the blueprints, that kind of stuff. You just kind of need to have the basic idea.
Okay.
Wow, dude. So, dude, that's crazy. So many patents are just flying around. Like, do you think they're ever gonna run out of ideas? Like,
Uh, well, I forgot what it was, but there was a Roman emperor that basically said that we were at the apex of human, you know, advancement. And of course, there's always going to be new ideas.
Yeah.
true. Yeah,
Yeah. And the big
that's
one
good.
now is AI.
Hmm.
Oh, yeah, that
Which
opens up a
can
whole
you
new thing.
patent that? Is that patent?
No, that's a lot of weird stuff right now. So the way that the patent law works is that a person has to invent it.
Hmm.
And so
So the
when you
algorithm could be patented, maybe, or
algorithms are tough. So this gets in a little inside pull. Software is really hard to patent now. There was this decision called the Alice decision. And it basically just said that software is nothing but electrons, and you can't patent electrons. And this has always been the case, but we used to use this little trick and say, well, it's electrons, but it's on physical memory, like the hard drive. And that was the physicality. But, the Supreme Court said that's a silly little trick. We're not going to do that anymore.
Yeah.
So there are some software items that you can do, is like, one of the exceptions is say that you make internet transactions more secure. Another one would be that you make computers work more efficiently or the internet work more efficiently. But most of the time, people call like, hey, I got this great idea for an app. It's not likely to be patented. But even
Okay.
when we could, it really didn't work because the patent process was so slow and software moves so fast that even when we were getting software patents for our clients, it would be like 5 years later and be like, thank you very much for doing that. But we stopped using that 2.5 years ago.
Yeah,
Yeah, facts. It's
that
like
makes
coming out
sense.
with the lightning cable when they moved to USB-C. You know what I mean? It's
Yeah,
like,
exactly.
dang,
For real.
dude, that's crazy. Like, because it's like you're always like inventors are trying to stay like in the future, really, and be like, okay, what's gonna work out in
Yeah.
the future? That's crazy to think about.
Yeah.
I have another question about AI. Uh, and I don't know if you've dabbled in this, but so AI, like they're making songs now and like stealing people's voices, like famous people's. Like I think Drake came out with a song and he didn't even come out with it. It was AI. So can you patent a voice?
No, no. So that would fall under copyrights and stuff like
Okay.
that.
Hmm.
And name, image, likeness, same NIL stuff that you're dealing with,
Yeah.
in that same vein of cases that you're dealing with the NCAA right now. But I know the AI stuff, man, it is it's crazy. And then like one of the my concerns is that especially like inventors are like, hey, I want to push this on AI and see what it comes up with. Here's my idea. Can you do it
Hmm.
for me? But understand one of the big issues with inventors and the stuff that they're doing is disclosure. Like, how you're supposed to keep your patentable ideas secret until you file a patent application.
Yeah.
Now,
Yeah.
the United States gives you 1 year from the date of disclosure
Hmm.
to file, and it's very unique in that. But if you want to file anywhere like in Europe and a lot of Asia, you can't disclose at all. Now, my big concern, and the, we don't really know until a court says something, but you throw something in Chat GPT, you've just disclosed it to the biggest knowledge base in the world, right?
Yeah.
So that's my concern with AI. And, people are looking to invent like, hey, I have this idea. Is it out there? And just by asking that question, you kind of told it what you're working on and what it might be.
Yeah. I've definitely made
Yeah.
that mistake.
Same. I just did that actually before the episode. Dude,
Yeah.
yeah, because then it's like you're given then somebody else looks up chat, like, give me a
What? Yeah.
invention idea, and it
Exactly.
gives you their idea, dude.
It
That's
could. Yeah.
crazy. Yeah,
Yeah.
man. That's pretty insane. I wonder what type of like schooling people that want to have your job, I wonder how it's like changed. Like what are they doing to like teach these new like patent lawyers like as far as AI goes? I wonder how that's like changed and stuff. Do you find it hard to like constantly learn new things and how it works, or is it pretty much steadily the same process with every patent?
It's kind of the same. I mean, unless you're like in that cutting edge, most patents are merely just incremental steps.
Mhm.
Like you'll go to so there's like thousands and thousands and thousands of patent examiners, and there are groups focused on the same area, and you will go and look in the patents in that area, and your mind will just get blown because everything looks the exact same, but there are like minute differences that do make changes, and then they get a patent on that change. So it's kind of hard to, I don't know what they're teaching these kids. Basically, the law stays the same, but your background changes.
Yeah.
So, there's always been a push. When I was going through it, it was kind of like engineers fell into the patent, you know, being a patent attorney or something like this. Now it's like we have a lot of kids who are actually going to engineering school or, medical or, something with a technical background with the sole intent of becoming a patent attorney.
Mm.
So that's kind of
Really?
one of the biggest changes. I think there's going to be a huge flood of patent attorneys coming out, and we'll see how that goes.
Yeah. So can you tell us like what can't be patented and what can be? Because like we were talking about this a little before the episode. Like obviously I can't grow like an apple tree and then patent an apple.
Yeah, you can.
Wait, you can?
You can. It's called a plant patent. You're allowed to patent new varieties of plants. I've never
New
worked on one. I've
varieties.
never seen one, but they do you it's called so there are three types of patents. You have design patents, which are basically just cover the way something looks. Think of
Mm-hmm.
like a Coca-Cola bottle. Like
Yeah.
anyone could make a bottle, but say they had a design patent on the Coca-Cola bottle, it would you couldn't make it look just like that. Uh, the utility patent, which is the patent that most people think of when you get a patent, it covers
Right.
the idea. And then there's a plant patent, which I assume there's very specialized people, probably worked at Monsanto and all this stuff, because yeah, I mean, they patent seeds all the time, and like there's been these crazy cases of like Monsanto, they'll plant a field, next to this independent farmer's field, right? And just by nature, wind will blow a seed from their crop over to his land. And then technically he's in trouble because he's using their patented product without permission.
Oh, that's messed up.
Mm. It
What?
is I mean that's one I do not agree with, but it's part of the law. So yeah.
Dang, dude. God can't be happy about you stealing his invention, dude.
Yeah, that's
Like, think about that.
crazy. You can patent a seed?
Yeah,
Like,
you patent the new plant. You GMO'd it. I mean, all that GMO stuff
Yeah, dude.
is
but if
patented.
it's natural, then you can't.
Correct. Like, yes, because technically it's been disclosed. So
Yeah.
there are other things too. Like, I mean, they patent gene sequence. There's a way to like when, when you're dealing in the biological arts and you have genes and stuff, there's actually databases that you upload the patented gene that you're trying to, or the gene that
Mhm.
you're trying to patent, the sequence to the USPTO. And obviously that's a massive data dump. Um, and I've never seen one, I've never touched one. That is totally outside my sphere of influence. I do more, mainly mechanical, electrical, those kind of things. So
Yeah. Dang, dude. So, do you think that like Granny Smith apples are owned by somebody named Granny Smith? Like, do you or are those natty?
yeah, they may be. I mean, the ones that I see now, like I have a friend who loves them. They're called envy apples. I've never seen them before, but I mean, I'm sure
No.
you've seen the cotton candy grapes.
Yeah,
Yeah.
Those are probably patented. I mean, I don't know. I haven't looked it up, but I
that's
Yeah.
assume
crazy.
someone spent a lot of time getting them to taste like that, that they're going to protect that.
Wow.
Wow.
Yeah.
That just kind of
Dude,
blows my mind, dude.
I know.
And there's
Like
some
now.
weird stuff with like, they have used people's tissue to pull out DNA segments and, bioengineer other, you know, biologic type stuff. And then there's been lawsuits of like, hey man, you used my you used
Yeah.
my like kidney that was removed. I said you could use it for science, not
You
that you
use
could.
my use my
Yeah,
elbow, dude. Like,
exactly.
what are they patenting when they do that? Like, I just
Oh, man, it's state of the art is just, I mean, it'll blow your mind if you look at some of the things that, people are doing.
Yeah.
yeah.
Like, whenever you send in a patent, uh, who's, like, approving it? And do they always get approved? Like, is there, like, certain criteria you gotta hit, and then it's like, "Alright, yeah, we're gonna get this approved," or is it scary? Like, sometimes you're like, "Shoot, I don't know if they're gonna approve this." Who's on the other end of that?
That's a patent examiner. So, what I always say is like there's one US patent office, but there's really like 9,000 or how many patent examiners there are because
Jeez.
every examiner is different
Mhm.
and they're kind of like their own little patent office. So, you will deal, with sometimes you'll have these very difficult examiners. There's examiners out there and you can look up statistics that have almost like, one patent allowed in 10 years or something like that. They just do not allow anything. You have other examiners that are, hey man, I get what you're saying. That's cool. Let's go. Um, what's best is probably the in between because you do need someone to, you know, kind of like you need someone to basically go through and say, hey, we got to test your patent out. We got to make it stronger by weeding out some of the issues that might be there. And so I appreciate tough examiners, but I, they need to be fair as well.
Okay.
Yeah, but it's a risk. Even if you get your patent allowed, doesn't mean that a court won't invalidate it later.
Mm.
Oh,
Yeah.
So it goes through like a different, dang, it goes through a big process then. Has has anybody ever tried to like bribe you to like be like, oh, like I'll give you 20% of the company if you like give me a patent?
Yeah,
Or does
no.
nobody do that?
No, I mean, as the attorney, a lot of clients come up and like, "Hey, can you do what, personal injury does? If this patent makes it, I'll give you
mm,
20% or 30%." Unfortunately for patents, it's too speculative. Like we said, getting the patent's the easy part. It's the, you know, building a business, getting it out to market, doing all that stuff. That's
Right.
the true test. And I got to tell you, sometimes I've seen patents come across my desk and I've been like, all right, man, well, sure, we'll go ahead and get you a patent on this. I mean, I don't know what you're going to do with it. And they
Dang,
blow me away with what they've been able to do. And then,
dang.
sometimes you're like, man, I would love this idea. I would totally buy it. And then it goes nowhere.
yeah, that sucks because like if somebody else got that patent, maybe they could have made it succeed, and then you could have bought one or something. Like it could have been on the market. But sometimes it's
True.
really like up to the marketing, and it just fails, which kind of sucks.
But then you just describe what patent trolls do.
Oh yeah,
Yeah. So
they
what
don't
they
do
do is
anything.
what huh?
Do they just like patent it and then not do like anything with it? I'll let you talk. Sorry.
Well, no, no, no. But that's no. You're exactly right. That's the definition of a patent troll. They hold a patent and then they do nothing with it, basically setting out landmines and then trying to go
Oh.
after people when they sit on them.
Mm.
Or is it, like, with the intent to sell them? Kinda, like, to drive the price up on it? Because you can sell the patent, correct?
Correct. You can sell any piece of
Mm.
property you have.
Yes.
Um, so what the business model for most patent trolls is they go find distressed companies. And then when they go into bankruptcy or whatever, or they're broke, they buy their patent portfolio, hold them, bought
Oh,
them pennies on the dollar, and then just wait around hoping that someone steps on a landmine.
that's kinda
You guys
smart.
are too young for this, but BlackBerry, do you remember Blackberries?
Yep.
Oh
Yeah,
yeah, yeah, yeah.
they got hit with one of the largest patent. I think it was $750 million at the time. Don't quote me on that. It's just something outrageous, and it killed the company because a patent troll company had bought a patent from a distressed internet.com bust company that busted, and, they made the return on their money. Then some.
Dang.
That's
I feel like
dirty,
it's
dude.
kinda like domain names in a sense where it's like you have the domain trolls too that are buying every single .com, especially with, like, new and up and coming companies, they'll just buy their name first, so then
Yeah.
they have to kinda come to them and, like, screw them over on a price.
Yeah, that was kind of the base of I'm not too familiar with the specifics of the law, but it was the Cyber Squatting Act. And it was basically
Hmm,
like they can't make money off of owning it. But I think if they just own it and don't use it, I think they're okay with that. Because I remember when it first started, like, guy who bought McDonald's.com, he made a lot of money off of that one.
I bet.
Dude.
Yeah.
Yeah, that's like winning the lottery, dude. Yeah, we've bought our fair share of like website like domain names, trying to come up with companies and stuff.
Yeah.
I think we just held on to because it's like, why not?
Yeah.
But dang,
Yeah.
so does the law ever like really like probably not very easily, but is there any like changes that have occurred over the like past few years as far as patents go that you have to adjust to, or is it all pretty much the same?
Well, I mean, it's act of Congress type stuff.
Right.
So,
Yeah. Yeah.
the biggest thing we have to, and even like the Supreme Court cases rarely come down because, you know, most most judges are not technical people. And when they see the patent case, most of them are like, I don't, let me, maybe I can pass this on or whatever. I mean, so
Yeah.
that's kind of how patent is kind of like this redheaded stepchild. And I apologize, redheaded stepchildren, but
No, we love our
like of the
gangers.
law. Yeah. So, and then, acts of Congress, they take forever. So,
Yeah. Facts. Yeah. Yeah. No, that's
Could we
true.
talk about, like, some patents that you've worked on? Like, what are your favorite ones that you've seen? Like, maybe some specifics for our audience of what you've actually worked on?
they're kind of all over the place. There was this one where, I mean, when I was a patent examiner and I just got there and I was 22 years old, I guess 21 years old. And I worked on a Jägermeister machine. I thought that was kind of cool.
Hold
Dang.
on. What? Am I stupid? What is that?
Have you ever been to the bar and they have the Jägermeisters upside down
Yeah.
and they pour out the Jägermeister?
Oh yeah, yeah. I think
Yeah.
so. Okay.
So, and then like my
That
first
guy's
day,
probably rolling in it.
well, it's probably the company. Yeah, exactly.
Yeah.
Yeah. Most
Dang.
Dang.
inventors work for companies, and it's the
Mm.
companies who make the money off the
And
invention.
then the company owns the patent. Yeah.
Yeah. So,
Wow.
Hmm.
Um. Yeah, I had a couple patent ideas that I wanted to run past you, see what you thought.
as public
Um.
disclosure, as an attorney, I would tell you don't tell everyone about them. But
They're
whatever.
not. They're not very
They
real.
can have it, dude. If they make it work, bro, they can have it.
Okay.
Um. Okay, so the first one is okay. So a smart mirror that gives compliments. So like, so you're doing your hair in the morning. It's like, dang, like you're looking wavy right now, Brayden. Or like, oh, like go, like have a great day, Mr. Bonder Paddington.
Yeah.
Like
I
it would
know
just
she
like
didn't
give you.
say anything about my hair with it. That's cool.
Oh no, no, no.
It was like, oh, you have a good day, sir.
Well, but like it could be honest too. Like the mirror could be honest, or like if
Yeah.
I'm being too cocky or whatever, it'd be like, bro, like chillax. You know what I mean? I think that'd be kind of cool.
Yeah. Like, like my son, he would love it to say, hey, you've been 30 minutes in this mirror. It's time to go.
Yeah. Yeah, dude. Oh, dude, I just came up with another one though. Yo, so you know Just Dance,
Yeah.
the game?
No, I don't.
Okay, so it's like a game that like you dance and it like sees your movements and it'll like rate your dancing or
Oh,
whatever.
okay.
Like,
Gotcha.
what if you put that in the mirror and it was like you could wake up, hit a dance in the morning, and it's like, I don't know. You think it's stupid?
No, no, well, think about it. There is a mirror workout device that people use, and I
Yep.
guarantee you
True.
there are
We
patents
had
on
one of
it.
those. Yeah.
That's
Yeah.
true. Yeah. Hmm.
So the idea that, it's silly or this, no, it's not that. I mean, that may prevent you because they already have, those kind of things. But,
Right.
a lot of times I tell people that while the broad idea might be not just in view of prior art, not patentable, it's how do you know if you should, look into if you have a patent? My answer is, did you solve a problem?
Mm.
So say that you had this idea and you wanted to make the mirror and you're like, oh, it's just a TV and this and this. But when you get down into it and start doing the nitty gritty, you're like, there's a problem I had to solve. And that problem that you solved might be the patentable part that would
Okay.
that allow you to get an invention or a patent on the product such that no one could make a mirror that complements you or calls you on your BS, those kind of things. It's the problem that you solved when you get down to the nitty gritty could be your patentable hook.
Yeah. Okay.
Yeah.
Um.
Hmm.
Wow, that's crazy. There's one more idea that I had that I want to run by you, and then after that, I kind of want to. I'm interested to see like some crazy patents that you've come across, if you can remember any. Um. Okay, so this one is a dog translator caller. So say your dog's like barking or whatever, it translate it to like something in English, like yeah, I did just poop on your couch. What are you gonna do about it? Type stuff. Or you could change it's like sass. You could change it to nice. Like you know what I mean? So it's like people want their dog to talk. Like I know, like that was a dream of mine. Like when I was a kid. Now it can.
Right.
That's
So
kind of
the
cool.
issue with that would probably most likely go against that what's called the that Alice decision. And what they would say is that basically you're taking barks, which is
Mm-hmm.
sounds, comparing it to a database and then spitting out,
Hmm.
a result.
Mm-hmm.
And to them, that's considered just soft.
Oh wow.
Oh wow.
Even though you have the physicality of the microphone and the speaker, those are considered
Mhm.
generic elements. They're so well known that you can't just say, "Hey, I attached it to the speaker and a microphone, and therefore I have physicality." That was the
Yeah.
decision in Alice. Basically, like you can't use these generic little well-known items to give your software physicality.
Dang.
Wow. Okay.
Do
Hmm.
Yeah,
Do you know if anyone's ever patented like the spoon or like a fork?
Hmm.
the spork, right? I mean that may have been patented.
That's a cash cow.
Yeah,
Dude,
exactly.
you guys seen the spork knife, dude? The spork knife?
No, I
It's
haven't.
insane. It has a knife on the back
It's
and
just a
it's
pocket knife at that point, like
yeah,
like a
Swiss Army knife.
yeah, Swiss Army knife. Yeah.
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 Yeah. Bear
Dang.
Grylls
So,
uses it.
dude, dude, yeah. Um, so I want to hear like some of the craziest patents you've come across.
Yeah.
Well, I mean, honestly, in the areas I've been in, they're not too crazy. I mean, I've worked in like some heavy duty electronics, consumer products, and stuff like that.
Hmm.
I've worked in carbon nanotube technology. A lot of that stuff's super cool if they can make it work. Like carbon nanotubes will be the strongest, if they can make a cable out of it, but it's really hard to, do it. So, those are the kind of stuff, but in reality, not much. I mean, it's cool, but it's all incremental. It's nothing that's
Hmm.
been mind-blowing type stuff. And, I've worked on some, but I wouldn't really talk about it right now.
Do you own any?
Actually, yeah. I mean, that's basically I patented some ideas. I have some patents under my name. Uh, just little bitty things. Me and a buddy of mine were into compounding pharmacist type stuff, and one of the things is that when you're basically, one of my inventions was, me and a buddy of mine, is that you have white powders and you mix them with white gels. How do you know they're mixed? And it was just super simple. You just put a little coloring agent in there. No one had done it before. Got a patent on it. But as soon as we started doing this, they started cracking down on compound pharmacists. So, sometimes you hit the market, sometimes you don't.
Mm, okay. Yeah,
And
that's so true. Like you probably sometimes work so hard to get a patent, and then there's some like extra variable out there that just comes in when you're not expecting it. It just ruins everything.
yeah, well, that's business. I mean,
That's true.
I tell
But like the
everyone,
patent could be like a year-long process too. It could be like, you take forever to get, and then I don't know. It's
that's
hard.
right. It's like having yesterday's mousetrap. You're like, yeah, it's great, but something better came out. So,
Yeah,
yeah, part of it.
yeah, definitely.
Yeah, and that's why I tell inventors too. And don't stop. If you're marketing a product and it's getting out there, you need to have different versions in your back pocket, and it has to keep getting better, or someone's going to, I mean, it's commerce. That's the way it works.
Does anyone ever call you like Doctor Patent?
No, no. Even though technically a lawyer is a juris
Exactly.
doctor. And I'm like, you
Exactly.
could call me doctor. Maybe I can, no, but no.
I've heard that a lot. That no lawyers like being called doctor. So
Uh, yeah, no. I'm not a real doctor. I'm not going to say, I mean, if you're choking, I might be able to save you, but everything
see, but
else,
neither is like someone with a doctorate in philosophy. But they're all like, "Oh, I have my doctorate," you know.
yeah, exactly.
But they're not saving anyone.
No, they'll lecture you when you're choking on it,
Yeah,
and
yeah,
exactly.
exactly. Brayden, you got some. Looks like something's on your mind. Something heavy on your mind.
Yeah. Yeah, yeah. I'm trying to think if it's just the stupidest question ever or not. I don't know. I was just thinking like, okay, like as far as time travel goes, like if there was a time traveler, he came to our time right now
Okay.
with, oh man, from the future, he came in with like a invention. I'm just trying to think how the patenting process would go. Like, would you have to patent that? Like, I don't know. You probably would still, right? I
Well, you
don't.
don't have to. I don't think it's
You
just
don't
for
have
your
to.
own protection.
Right.
That's true, but what if he made like, oh man, I don't know. It just gets complicated at that point because like he could already be selling it in the future, and then it's like, I don't know. I don't know.
Well, what you're saying though. If I hear this correctly, this guy from the future comes from the future, comes back and goes, "Hey, we have all these cool stuff in the future. I'm going to patent it in the past." But there is a thing
Mm,
you mentioned, like, hey, if someone can make a patent off of what I say today, good for them. But you can't, because you can only patent your inventions. And this goes back to the AI. So a
mm,
person has to invent, and the person applying for the patent has to be listed as the inventor. So
Okay.
you actually have to sign a declaration. I believe I'm the first person to come up with this idea.
Oh. And do they have expiration dates?
Yeah, so the patents last, they're now 20 years from the date of filing,
Oh,
but it
wow.
right, but you gotta pay maintenance fees, and the other part is that there's no, like, real status or, you don't have any legal rights when you have patent pending, only when it's allowed. So when you file the patent application, unless you pay an expedited fee, you're looking at 2 to 3 years before they even look at it. So that's why you
Oh,
have patent pending for so long,
Whoa.
and then hopefully you have it, within a certain period of time. If the office determines that they're the reason why it took too long for the patent to get issued, they will add to that 20 years at the
Okay.
end.
that's fair.
So,
But,
yeah,
like, you really gotta cough up some money in order to make them look at it quick, right?
I think it depends on, I think it's like $1,500 or $1,000, something like that.
Okay. That's not too bad if it's, like, a solid idea, but
Oh, yes,
Right.
that's a cruise.
And some people are okay with the patent pending status. Because I always tell them, if you have a good idea, it's going to make money. I mean, look around your office right now. Half that stuff does not have a patent on it, right? I mean, people make money all the time with things that
mm,
are not patented. So if your idea is good and you think you can make money off of it, go do it. Don't just wait around for a patent.
but what if someone then saw their cool product and then paid the expedited fee to patent it before them, even though it's filed?
Right. No, it's first to file always wins.
Okay.
Okay,
That's
that's
So
good.
yeah.
fair.
And then
So as long
two,
as
they
it's
would have
filed, you're pretty much safe.
right. That's when you get your date. And then the other
Okay.
thing that you also have is that person saw your idea and it's called derivation. So, like I said, your first public disclosure, you have a year to file a patent application. If someone beats you to the office during that year, they win, unless you can prove that they got the derived the
Mm,
idea and the invention from you.
that's hard.
Mm,
It is hard, and it's not
yeah.
something I would suggest. I would suggest just file the patent application as soon as you
Yeah.
can.
But what if it's like, okay, patent pending, someone else makes the product and they're doing great, but you can't sue them yet because your patent's still pending, right? But then
Yep,
whenever it gets approved, then you can sue them or
correct. Yeah,
okay.
Oh,
and I
okay.
kind of tell people sometimes, like, I mean, it stinks. Like, it's not great.
Mhm,
But what's one of the hardest things with a new product? Developing the market. And if
mhm,
someone's out there willing to help you and obviously, they're developing the market, they're spending all this money on advertising, and then you all of a sudden your patent issues and you make them stop. People know of your product now, and then they're going to search the internet and they're going to find something similar, right? I mean, they're going to find your product.
Mm,
So it's not great, but it's sometimes, I mean, glass half full, you got to look at it that way. I would. So yeah. And two, if
yeah,
someone's making tons of money off of your idea and you know you're going to, and you get that patent, gold mine. I mean, you are just, or,
yeah.
or,
true.
or you license it to them and then you get what I call mail money. Because that's what everyone should be working
Mm,
towards
passive
is money
income.
that comes in the mail.
Yeah.
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 And then
Oh,
you
yeah,
never had to build it. You never had to do
or
anything.
market it or anything.
Yeah. So
Dang.
one of the inventions I had, and I apologize, firearms and stuff. So California had this new rule where you couldn't have a detachable magazine in this. So I came up with this, cl- little idea where you stick a on the brake pin, you stick it in there, and it basically a bumper, so you could uh, disassemble the weapon and then detach your magazine. But the issue was is that top part was so heavy it would just flop all around. So this made it safer. We did it, and then we end up beating a guy with the same idea by like 3 months to the patent office.
Dude, that
Yeah.
is close.
And did you have a real product at that point, or did you just have the idea?
No, no, he was end up making the product, so we came to an agreement, and that was kinda how that went.
So you
Yeah.
just kind of wrote on paper, like, tell us how that works. Like, when you send this in, what are you providing the patent examiner? Is it, are you drawing a picture? You writing some words?
All of it. So, I mean, if it's a mechanical device, you provide pictures, then the write up is a specification, then the most important things are called the claims. The claims define your invention. So it's kind of like, you stake your claim, like old property and stuff like that. And then the claims define the meets and bounds of your idea. So I kind of explain it like it's a list of elements, A, B, C, and D. And any product out there that has those 5 elements with, the other, restrictions infringes your product. So, say that someone else had A, B, C, D, E, F, and G, even though they made it cooler with a bunch of other stuff, if they have those elements in their product, they are infringing.
Okay.
Did that
Wait,
make
they have
sense?
to have
Or I'm sorry, I think I
I think
lost
I
you there.
kind of lost you.
so they have to have all of those elements,
So in
or
your
just
claims, say that you have 3 elements of your claims, A, B, and C.
okay,
And anybody who has those elements in any product they make or sell is infringing your patent.
okay.
Mm,
Just one, like, could it just be one of those elements, or does it have to be all three of them?
It has to be all of them.
Okay,
So every element of the claim has to be met in order for someone to infringe. So
okay,
what you're looking for are very broad claims. The patent office does not want you to have broad claims. So you argue with the
right.
examiner, and that's
mhm.
the back and forth. But the less elements, the broader your invention is, and the more people you can box out of your idea.
Yeah, okay. So it'd be a strat to have less then, is what you're saying? Because
Right. Less is more.
yeah, they're more likely to infringe upon it. Okay, I'm tracking.
Yes. So
Gotcha.
Yeah, I feel like people really need like a patent attorney when it comes to this because
For
yes, you
sure.
like I think there's a way to do it yourself. I'm not quite sure, but I think a patent attorney is definitely the way to go, especially to like deal with almost like the customer service aspect of
Mhm.
the US government, like especially when it affects like your whole business, like a patent
right.
would.
And that's the other thing too is like, it is a skill. It's something that takes a long time to develop. I value my time at the patent office because I read patent applications every day, and that was probably the best training I could have had. But one of the issues with inventors, and especially they're too close. And so they're too specific about their idea. They know exactly what they want. And, I'll put in there like, it could be made out of wood. And, the inventor will come back, no, it has to be made out of this specific steel because then it's going to be good. And I'm like, we all know that people are willing to pay less money for inferior products all the time. So you need to be able to, broaden out. Basically, you're boxing people out with the
Yeah.
scope of your patent. Cover your idea, cover your specific model, cover what you're selling, but you want to box people out so they can't even get close to you.
Yeah.
Yeah, that's definitely the smart way to do it.
Yeah.
Um. Okay. So I was thinking back to what you're saying. What was the term you used for like why you can't use AI? Like it has to be your idea. What was the term that you used for that? Where it was like, uh,
It's basically for AI. Well, the issue was disclosure. So
okay,
if you disclose, then you might lose your patent right. Um, for basically what I think the term you're looking for is derivation when we were talking about someone else taking your idea.
yeah, yeah. So I think that's what I was thinking of. So
Yeah.
does that apply for people like from other countries? Like, say I get an idea from somebody in China or somebody in Australia, it still applies, correct?
Yes. Yes.
Okay. So like so you can't just take like a like I think I saw somewhere that people were like remaking these websites that were like founded for like a different country and they were remaking them in America. And I was wondering if there's like different rules with that or if it's like the same thing.
Well, that's the problem. You can't patent software anymore, so it's really hard
Oh,
to
true.
patent, those kind
True.
of things. But I mean, take one of the big things I've heard about now is that there are companies in Asia. Soon as something hits Kickstarter, they're already making it and
Mm,
selling it before the person can actually develop, raise the money and build the product.
Oh, dang. Okay, so they're sniping people on Kickstarter. Like they're taking their ideas from Kickstarter?
Yes.
which
Wow.
totally makes sense. Yeah, because
Yeah.
a
Yeah,
lot of
it
those are
does.
pre-patent things. Almost all of them on
Mhm.
Yeah.
Kickstarter.
They should have already had a
Mhm.
patent, but yes.
Yeah, but a lot of them, yeah, they don't think like that. They just,
Right.
oh.
But they might still be able to get it unless someone, gets
Or they're
ahead
at
of
least
them.
pending. Yeah.
Yeah. So, and that's the other thing too, like patents are only geographical. So if you have a US patent, only good in the United States.
Hmm.
Okay, yeah.
So
Yeah.
yeah, okay. Because I saw a Japanese one that was similar to like something I wanted to do, but I would still be able to get one in the U.S. then,
No,
or
so
no?
that's the thing. Like I mentioned before, is So I explain to my clients is that, we do a prior art search, we spend a limited amount of money on it, and that gives us, you know, assurances to move forward to writing a patent application and filing it and spending that money. But no search is 100%. And while we might spend 700, or I'm sorry, like 1500 commissioning a search, they're only going to search, 7 hours. They're going to search the United States. They're going to search what they know. If your patent hits it, or sorry, your product hits it big, someone might pay hundreds of thousands of dollars to search all over the world for a patent,
Dang.
or some other, hey, this, car seller in Korea was doing this little thing. We're going to use it against you. Something you could have never
Oh.
found, the examiner didn't find, you had a patent that was issued, and then they come in and invalidate it.
And what do they get out of invalidating it?
Anyone can use it. So you basically knock down the wall and everyone can run in.
Oh, dang.
Yeah.
This is more complicated than I thought.
Not really. Just think of it this way: your patent's only valid unless someone they can prove someone else disclosed it before you filed for your patent application.
Okay.
Yeah. So
Okay.
Man,
yeah.
I'm just looking around like the office right now, trying to figure out like what I could patent.
Everything. Like, is this lightsaber probably like this? Yeah, this is definitely patented, bro.
Uh, well, that's the other thing too. So you can have what's called design patents. So take your microphone right there, right? You can't get a utility patent on a microphone, but you can get a design patent. And a design patent basically covers
Right.
just the way something looks.
Okay.
So that's
Ooh.
another avenue I tell people is like, look, even if you're building a product that doesn't have a patent or can't be patented utility wise, you can protect your molds, you can protect your design
Mm.
by doing the design patent. And that way, no one can sell a microphone that looks just like that if it happened to be, um, yeah, if there
Dude,
happened to
that's
be a design
like
patent.
that's probably why ours like looks so different too.
Yeah.
Yeah. What? Dang, dude.
Huh.
That's crazy. I'm trying to think. So, like, what if I made a microphone that looked like
Oh God.
like, like
I don't know. I
like
don't know where this is going.
no, I'm just saying. I don't know. Like it looked like something else. Like they could get me for that if I made it look like a um one of those vacuum cleaners, like the iRobot things. Like they could get me for that, but it was like a different product. If they have the
Possibly.
design,
Yeah.
if they have the
Yeah. If
design
it looked
patent.
too much like the iRobot, there might be an
Mm.
issue. But yeah, I
Okay.
mean, yeah, say if you, made it look like a generic, you know, vacuum cleaner. Yeah.
Okay.
Okay. Hmm.
Do you ever deal with trademarks and stuff like that, or is that in the same market as patents?
It is. So only patent attorneys and patent agents can handle patents before the USPTO, but
Okay.
any attorney can be a trademark attorney. And there's some misnomers there. So everyone's like, I gotta get the government to give me my trademark. I'm like, no, you have a trademark as soon as you put a product or service in commerce. The question is whether or not you can get it registered. And the registration is what the trademark office gives you. Once it's registered, you get federal wide, US statewide, I mean, US wide protection. Now, if you were to take certain things like understand American Airlines is not even trademark or does not have a trademark registration. It has a trademark, but because it's descriptive, it's American airline, they can't get a registered trademark on it. Now, they might be on the secondary register, which is something else, but if you ever notice, they don't have an R with a circle next to their name.
But I guess it's not too big of a problem because that means no one else can do it anyway, right?
Right. I mean, that's because they have common law protections.
Mm.
They're so widely known. I couldn't call myself American Airlines, but Delta can say, I am an American airline.
Oh, this is true.
Yeah. Because you can't, it's hard to register things that are descriptive because I mean, once you trademark something in that area, you've removed those words from the lexicon in that area. You basically said, you can't use these words. If you're, say in the airline industry, you can't use these words. But because it's descriptive, they can't get a
Ok
registration. Yeah.
but you can only trademark something that's, like, uh, that, like, is branded, like, something that you're selling, right? Just not, like, a phrase.
No, people, do phrases too. I mean,
But
there's
do they
ways
have to
that
be
you need to
associated with a brand, or can it just be, like, anything?
it has to be associated with the brand. You
Okay.
can't
Like
just do
slogans? Yeah.
slogans. But if
Oh.
the slogan gets so well known, right?
Yeah, you could just be like, "Yo, that's my word, dude. Don't say that, dude."
Well,
Like if
I
you
mean, you've heard about it. I mean, every time I think, every time I think if I'm not mistaken, I think one of the Hilton something, she tried to trademark "That's hot" or something.
Paris Hilton? Yeah.
that's
Yeah,
crazy,
something
dude.
like that.
Or like
Yeah.
like Oliver, imagine somebody try to mark like trademark like D's nuts or something, and then anybody cracked a D's nuts joke, you have to pay them.
Yeah, exactly.
That'd be a huge problem. That'd be a huge problem.
Yeah.
Right.
Dude,
Well,
wait.
understand that it's a little different. You would have to be selling things.
Mhm.
Right, right. That's what I'm
On
saying. So you
yeah.
can't do that, which is good because otherwise it would just be a mess on the like elementary school
Mhm.
playground. People would be like, "Dude,
Yeah.
that's my word. Pay me." Like,
And,
yeah.
like,
So
we can't trademark, like, "This dude started something," probably. Like, our podcast is called "This Dude Started Something."
Yeah, so you could trademark that.
Oh, we
because
could?
it's like
Yeah.
a brand, right?
Yeah, it's a brand.
But
Yeah,
I thought
you
it was, like,
create it.
descriptive.
No, I mean, you're not talking about a podcast. I mean, you would if you were like, you know, podcast or, radio show or something like that.
Mhm.
But even like if you were like, you know, this dude started something podcast, you would have to disclaim podcasts, basically saying other people can use it, but you
Okay.
can get right. And so,
Mhm.
anytime someone starts a new business or, and they're not ready to register their trademark, you've seen that little TM
Yeah.
on thing.
Yeah.
Use that. And that basically, tells everyone that you are going for the common law protection of your trademark. So
Hmm.
at least you're letting everyone know that this is a trademark. Don't use it. So
Yeah.
you get common law
Oh.
stuff. So
So we
since
can
you
just
got
throw that on there?
yeah,
Oh, let's do it.
Let's do
yeah.
it. Dang, dude.
Our lawyer said we could.
Dude, I just realized what the word disclaimer meant. It's literally like you're not claiming something.
Well,
You know what I
yes,
mean?
right.
Ooh,
Like think
that's
about it. Like nobody ever like everybody's like, okay, disclaimer. Like before they say something, because like, okay, don't like, you know what I mean?
Don't
Mhm.
hold me to it.
Yeah,
Yep.
exactly.
Yeah.
I don't think people realize that. I didn't, at
Yeah.
least.
That's so
Um, so when we're talking about the Southwest like airplane, it got me thinking, what's the process like for when you want to make like a little toy Southwest airplane? Like you know what I mean? Like you've seen um like trucks, like semi trucks with Coca-Cola on it. Like, did they just have to talk to the brand and give them like a percentage then of the money?
Yeah, you have to
Yeah.
come up with some kind of licensing agreement, especially
Mm.
Coca-Cola, man. They will not let you touch,
Oh,
anything. It's yeah,
okay.
dang.
Gotcha.
yeah.
Yeah, that's interesting. Hmm.
I don't know if you guys have ever seen Coming to America. I mean, it's an old one, but part of the story was there was a knockoff McDonald's called McDowell's, and it's just kind of funny, and they're always arguing and stuff like that. But yeah, so
Dude.
yeah,
That sounds like an engineering firm or something
yeah.
like that, or like company.
And
That's
believe it or
funny.
not, like one of the best patent and intellectual property shows I've ever seen that's real, can be raunchy. I actually enjoyed it, but Silicon Valley, have you ever watched that?
Oh, yeah. Yeah, I've seen a little bit.
Yeah. It's so good on the front of, it's like don't you like if you have an idea, do not use your employer's equipment. Keep it at home.
Mhm.
Don't, intertwine those things at all because once you use your employer's equipment, it could be considered theirs.
What
Dang.
about cryptocurrency? Can people patent their coins?
That I have no idea about.
Okay.
That one I wouldn't
Yeah.
know, yeah.
That's
Oh,
like kind of like AI. It's kind of like a whole different section. Like AI is kind of starting to be.
yeah, it's definitely in the software realm, so
Yeah.
Yeah, I think their protection would come in the trademark of the name and
Mm,
then, those issues. But I think the algorithms themselves, it's very hard to patent an algorithm. I don't really think you can, um, because there's a debate whether or not, like, math is just nature. We've just figured some things out, but it's always been there, right?
right.
Mm.
Yeah.
It's true.
Um, I was thinking when we were talking about McDonald's, could somebody, I don't know, I wonder if they have this trademarked. Like, could somebody start selling stuff at, you know, like, could somebody sell a Mick car or like a Mick glass of water or something? And like, like, would that be a problem? Like, do they have the MC like trademark? Do you think?
I mean, they got it pretty narrowed down, but I mean, here's the thing, like, if you were like McDonald's oil drilling, and,
Ooh.
you could do that. I mean, I
Oh,
would
the Mick
assume, I mean,
drill.
this is all hypothetical, I'm not McDonald's, please leave me alone. I don't know. And don't take my advice. Do not go out and try to start McDonald's oil drilling. But as an example, what it's supposed to be is that if you're outside, like, no reasonable consumer would confuse McDonald's oil drilling with a McDonald's restaurant.
Yeah.
Okay, gotcha.
And that's, yeah. And that's the whole test,
Yeah.
is
Mm,
likelihood of confusion. So are you,
Okay.
okay.
yeah. So at the end of the
Huh.
day, trademarks are there for the consumer. They're not there for the company.
Okay.
So when you're buying a very expensive bag and it says that emblem on it, it's supposed to have that quality to it.
Yeah, that's true. I never even thought about that. It's like, like, if we didn't have patents, you could go in somebody's backyard and get a McFish, and it's like fentanyl. Like, it's not an actual McFish. You know what I mean?
Right, yeah. Yeah, that would be the trademark, but
Right.
yeah, that's the whole point, is that you couldn't
Yeah.
just you're deceiving people into spending more money on a product that they don't know about.
Mm.
Yeah. Yeah. Yeah.
Yeah.
Yeah. That's good.
So if we were
Dang.
going to try and patent a product today, do you have any crazy ideas or even markets or industries that aren't saturated with patents yet?
Man, I mean, they're all saturated with patents, but it's there's always more to have. I mean,
Mhm.
the thing is consumer goods. People are willing to spend, tons of money on things, and, you just find one that catches and people are excited about, then you can go with it. It's easier to, especially if you're younger and you're just starting out and you got a small bank, or, behind you, smaller products that are easier to manufacture and get to market, and those kind of things. That would kind of be my thought, because I tell, every inventor, like, independent inventor calls, is like, you need to push this to market. You need to have a business plan. You have to go out. You have to make this happen. You have to find the consumers. You got to build the market. Otherwise, you're just going to have an expensive piece of paper waiting there for you. And so sometimes people come up to me with, like, hey, it's not a car, but, something it would take that kind of factory to put together.
Mhm.
Hey, I want to patent this. I'm like, how are you going to make money off of this?
Mm.
They're like, well, I'm going to approach these companies and they're going to want to do this. And I'm like, while that does happen sometimes, it happens very rarely.
Yeah. And
Yeah.
also the company still holds all the cards and all the leverage because without them, like nothing's even going to happen with the product, you know?
True.
Right. And, sometimes it does happen. Sometimes they see your patent, they're like, this is amazing. We want to do it. And then, other things a lot of inventors think is that they're going to get 50% royalties.
Mm. Yeah.
5% is generally where you should be looking at for mail money.
Yeah.
Jeez Louise.
Do a lot of your customers have that exit strategy in mind where it's like, I want this patent in order to have a quick exit? Like maybe I do a little marketing, but my goal is an exit. Or do you think more of the inventors you deal with just really love the product?
Yeah. I mean, I mean, inventions are like their babies. I mean, they love them. They nurture them. They do all this stuff. It's hard to be dispassionate about it. But I'm sure if someone came in and offered them a huge ton, boatload of money, they'd be like, okay, yeah, sure, we can do this.
Dude, what amount of money would you like sell your kid for?
Hey,
You don't have to
Don't
answer
bring
that.
Jackson into this, man.
Yeah.
yeah, this is not bring Jackson into this.
I'll just play it.
Yeah.
Dude. That'd be
Depends on the
crazy.
day, right? Yeah, you know.
Yeah, true.
Yeah. Was it
Yeah,
good today?
true. He's 20% off today. Yeah,
Yeah, exactly.
that's funny, dude.
Man.
Yeah, Oliver, you got anything else?
I mean, we could start wrapping it up, but I'm trying to think of a nice closer. Yeah, we kind of went off the rails.
Well, that was fun. I enjoyed it.
You had a great vibe for like all the questions,
For
despite some
sure.
crazy ones.
Yeah.
So if anyone has a patent, they should reach out to Austin Bonderer. Correct?
That's correct.
Any idea, any stage, it doesn't matter.
Correct. Well, the one thing I don't handle is litigation, but if you're looking to get a patent
Okay.
and, and I've also helped a lot of companies get started. I'm not saying I'm a startup attorney, but I've done enough to say, hey, you need to get an attorney for
Oh
this,
yeah.
you need to get insurance for that, and those kind of things.
Hopefully, me and Brayden are gonna be hitting you up soon with an absolute killer idea.
Yeah.
Because we're always thinking, and then
Yeah.
we're like, oh dang, like that can't work. Like, do you think there's always a way to like make something work, or do you think like you really do have to have like the perfect idea?
Oh, no. I mean, honestly, if you haven't, what was the quote? It's something like, if you haven't started, if you haven't pushed out your point 1.0, and while, because it'll never be perfect. It will never be perfect. You have to file the patent application early, try to protect the early idea. And then if you make advancements, we can add to that later. But, it's never going to be perfect. And,
No, that's good
No,
advice.
that's
That's good
smart.
advice. Yeah. It's literally never gonna be perfect. So you just got to keep
Yeah, for
going,
sure.
keep filing new ones, keep making it better. That's kind of what life's about, you know. Just
Yeah.
got to get better every day.
Constantly
right.
moving forward. You know what I mean?
Yeah.
Well, that's technology, and this is why there's patents are here, and there's more
Mm.
patents being filed now than there were 20 years ago. So,
Yeah.
Dang.
yeah.
Yeah, that's wild. All right. Also, I like your beard. We can close it on that if you
And the
want.
hair, we got to compliment the hair
The hair.
because
Well, the hair is the
Yeah.
beard, but
we missed that
I
opportunity earlier.
no, he did. He told me the mirror would compliment his hair and then tell me I'm to have a nice day.
oh man,
Yeah.
There's no curls on here. There's no waves. There's nothing going on. Yeah. So,
this is
That's
funny.
fun.
uh,
All right. Everyone, thank you for joining us. You can wait, hold up. I'm gonna retry that. Austin, what is the website that people can reach out to you?
BondererPatents.com. So you just put in Bonderer and patents. I'm the only patent attorney with that name, one of the very few people in the world with that name. So feel free to just type that in and my name will probably pop up.
Dude,
Perfect.
that's awesome. It's like a German James Bond. That's what it sounds like.
Dude, he
Yeah.
sounds like your brother-in-law, Peter.
He does, yeah.
Doesn't he? I've been thinking that the whole time. It's
Yeah.
crazy.
Tell Peter I said hello.
Yeah, shout out
I
to
will,
Peter.
Yeah. He might be here.
All right, everyone, thank you for listening. This is Austin Bonderer. Thank you so much again for coming on. Reach out to him at bonderpatents.com.